Today, part of my practice, part of my practice is wills, estates, powers of attorney, healthcare directives, and committeeships. All of them are important for managing your estate and the estate of those people that you love. Heather, a number of years ago, came up with a nice little chart to set out a couple of key documents to sort of go together, legal documents to go together, and why and how they're related. Basically, I think it's great, so I've adopted it for all of my clients as well. On this graph, there are legal documents that are relevant before death and after death. And on the other axis, there are legal documents that relate to you, that is your person, your body, and your possessions. And this part here, before you die, is probably more important to you than this part here, because after all, you're gone at this point. So before you die, when we're talking about you and a legal document relating to you and your body, the healthcare directive is the legal document. And the healthcare directive, and also known as a living will, there's other names for it. In other provinces, it's referred to by other names, but in Manitoba, I refer to it as a healthcare directive because the government of Manitoba has put together a little form called the healthcare directive. And it's a good form. It's free, and you might as well use the free document rather than going to a lawyer and spending a bunch of money on having them prepare, 5 or 6 page long living will in old legal jargon. Under the healthcare directive, this is a legal document in which you authorize an individual to make medical decisions for you and on your behalf. That person is called your proxy. So the terrible situation that you need to imagine in order to understand when a healthcare directive is important is when you have collapsed and you are not awake and a medical professional has found you and they need to do something with you. Obviously, you're not able to provide any instructions because you're unconscious. That's the point at which you need a proxy. And the proxy is the person that you designate to make medical decisions for you. Now there's a legal principle that you may know about which is called informed consent. Doctors really care about informed consent because if you don't consent to a treatment and they do it to you and you don't like it later, then they can get sued. So, what doctors like before they do anything is they like you to consent to treatment. But here you are, in your kitchen, on the floor, passed out. You're not consenting to anything. So they really want a proxy. And, the fellas in the ambulance want a proxy. They want somebody they can call and say, we've found this person. She or he has named you as their healthcare proxy. Can you please come down or give us some instructions? And then if you have a healthcare directive and if they're able to find it and if it has a phone number on it and if they're able to get a hold of you, then you may be able to, your proxy may be able to give instruction. If not, it's a little more dicey. Depends. Probably everything will be fine. But when you're dealing with your health, probably may not be good enough for you. It's not good enough for me. So, you have in front of you, you have the Healthcare Directive. I'll just take a couple of minutes to go over it with you. At the top, it's very, very simple. At the top of the page, it asks you to put in your information. Name, address. You can complete that part. And then there's two columns. It says Part 1 at the top of the left-hand side, and then it asks you to designate a proxy. And then it says there's a space for a second proxy. Now, I guess you could have a third proxy and a fourth proxy, but they leave a little bit of room. Certainly need one. And having two is a good idea, because remember, I told you that they find you, they find the Healthcare Directive, they phone the number on the Healthcare Directive. If it's a home phone and nobody's home, or if it's a cell phone and the cell phone is off, that's not going to work. Then they should go on to number 2. Call that person. So it's good to have 2. So all you have to do is you write in the person you choose, and incidentally, get their consent. That is, your proxy should agree to this job. And then choose a second person. Make sure they agree. By the way, tell them, hey, I've got this thing, a Healthcare Directive. The lawyer said I should have it. It's if something should happen to me and a medical emergency should happen to me, I want you to be my proxy. Is that okay? And they say, sure, of course. All right, I'm going to put your phone number on it. Okay, that sounds fine. So you put their name and you put their phone number. Now, beneath that, on the form, it says, there's 2 little boxes. It says jointly or consecutively. I think it actually says consecutively first and then jointly second.
That's correct.
I've seen the form a couple of times. I strongly recommend that you choose consecutively. Check the consecutively box. Why? Because jointly means they have to both agree. Now they call one person, they got to hold that person. Okay, hold on for a second, I got to call the second person. Do you agree with person number 1? That's not going to work. Choose consecutively. They get the first one, great, they're done. If they don't get the first one, consecutively means they go on to number 2. Get number 2, okay, we're good. Off they go to the hospital. Then, at the bottom and at the top of the second column on the right-hand side, there are instructions that you can put with respect to medical decisions and treatment instructions. Most of my clients leave those areas blank, and you're fully able to leave them blank. It doesn't make it invalid to leave it blank. I do, however, have some clients who are Jehovah's Witness. And when I find out that they're Jehovah's Witness, I say to them when I'm assisting them in filling out the form, I expect that you do not want any blood products. And they say, why, yes, that's correct. Okay, then, you should indicate that on the form. Basically, if you write in treatment instructions or instructions with respect to your care and treatment, it overrides the proxy's ability to make decisions for you. You say, they can make decisions for me for all kinds of things, but there's one thing, blood products, I don't want that. And then you're in charge, you provide the instructions, it's on the proxy form. It's on the Healthcare Directive. Like I say, most of my clients don't have specific, most of us are not doctors, and most of us don't have specific treatment instructions. You know, don't use the defibrillator 1, use the defibrillator 3. I have no idea, right? I just leave it blank. Trust in your proxy, and then sign the form, which is the last part. There's a big area to sign. All you have to do is sign it, and the form is done. The government of Manitoba thinks this is so important that they have created this form for you. It is a legally binding document that you don't have to pay a lawyer to do. And you can make as many of them as you want. Unlike a will, for example, where there can only be one original will, you can have 100 healthcare directives scattered around your house. And the reason why I mention that is because remember what I told you. Imagine the scenario. You're there on the floor. The emergency personnel have arrived. They find you. Now they need to find the healthcare directive. So, where are they going to look? Well, there is a thing called an ERIC kit. This you can get from Age and Opportunity or all kinds of senior centers. You may be very familiar with it. That's what the emergency personnel are trained to do. They find you, they look on the fridge. Hopefully you have one, and the healthcare directive is in it. They open it up, they call, and everything is fine. But think about where you might be found. You might not be at home conveniently right by the fridge with your hand pointing to the fridge. You might be in a car accident. So put one in the glove box. That's where I would look if I was a healthcare personnel. You might be at the cottage. Put one on the fridge at the cottage. Wherever you go, think about it. Where's somebody going to look? And how about this? Tell people where it is. Your loved ones. If anything should happen to me, this is where my healthcare directive is. And you're my proxy. Don't forget, you're my proxy, and this is where it is. Right? Just make sure it can be found. That's healthcare directive. That is while you're alive, and it has to do with you. Now, the second thing about your stuff is the power of attorney. And the person who is legally authorized under the power of attorney is called an attorney. It doesn't mean they're a lawyer. It just means that they can act for you as if they were you. Now, power of attorney is to deal with your stuff. So, what we're really talking about is your money, your house, your bank accounts, your investments, your property. There's two situations where a power of attorney is essential. That is, it's always essential before you die. But while you're alive, there's two situations which usually are the situations that come up. Physical incapacity and mental incapacity. If you can't get out and go to the bank, you need someone to do that for you. And if you ask your friend, let's call her Joan, hey Joan, go to the bank for me. I want you to take some money out for me because I need to pay these bills. And Joan goes down to the bank and she says to the banker, I want to take money out of my friend's account. They should say, no ma'am, you can't do that. Now I should tell you that in some small towns, sometimes you can get away with it. And I have heard the stories of people saying, I've been going down to the bank and dealing with my friend's stuff for years. And I don't have any power of attorney. Usually that's the precursor to a disaster because there's a problem that has come up and now they don't have a power of attorney. The second situation is the mental incapacity. Now it's no longer because you're unable to get out or it's more convenient for you to have somebody to do it for you. You're perfectly capable of doing it yourself other than physically, but now you are no longer mentally able to do it. You can't remember things as well as you used to, or you can't remember how much money you have in the bank, or you forget about the bills, and deteriorated mental conditions leading to, dementia, where there's a detachment. In either situation, the power of attorney is the same. The power of attorney is choosing somebody that you know and trust to do it for you. You are legally authorizing them to act on your behalf as if they were you. There's a couple of different kinds of powers of attorney, but the fundamental for all of them is this: you need to trust the individual absolutely. They need to be capable of doing the job for you, and they need to be available to do the job. So, a couple of examples to demonstrate. Here's an example from my own personal life. My stepmother is Heather Dixon. My natural mother lives in southern Ontario. I love her to pieces. But we're a province apart. My natural mother and my father had 3 children. I'm the middle child. So I was the black sheep of the family, obviously. My brother, first son, became a priest. like my father, an Anglican priest, and like my grandfather, an Anglican priest before him. He's the good son. Obviously. I'm going to ride on his coattails. Hopefully, at the pearly gates, they won't notice. I'm just sort of doing one of these behind his shadow. The point is, he lives in British Columbia. He's a good man. He's a man of God. He's smart. He's way smarter than I am. In fact, he did a law degree, and he decided to become a priest. That shows you how smart he is. Then there's me. I'm the lawyer of the family, other than my, well, stepmother. And then there's my sister, who lives down in southern Ontario, with my mom. So I got a call from my mother the other day. And she said to me, I'm doing my power of attorney. I want to send it to you. I got it from a lawyer. I want to send it to you. Okay, Mom, sure, of course. And I want you to be my power of attorney. I said, Mom, I don't want to be your power of attorney. And she said, well, but you're the lawyer. You're the best one to do it. I said, choose Ariel, my sister. She's down in Toronto with you. You want someone to go to the bank? You want someone to deal with the house? She's the right one. Besides which, she's perfectly trustworthy, and it's not rocket science. It's a bunch of work. She said, well, okay. But I want you and your brother to approve of everything she does. I said, I don't think that's a good idea. But I can tell you this. In Manitoba, there is a presumption under the Powers of Attorney Act. Now keep in mind, you're in Ontario, Mom, and I'm in Manitoba, and I don't know what the law is. You know, there's this legal disclaimer, because I'm a lawyer after all. But there's a presumption, and in the law in Manitoba, a power of attorney needs to report to those people who are persons of interest to the individual who's granting the power of attorney. So, Mom, my presumption is Ontario law is pretty similar to Manitoba law. I haven't read the Power of Attorney Act of Ontario, but I imagine that there's a similar provision in that law. I don't think you should be requiring Ariel to report to me and my brother. But it's probably the case she has to do it anyway, unless you opt out of it. And frankly, usually I tell all my clients, do you really want to saddle your power of attorney with this? On top of having to do everything for you, now they have to do a report, and report on all of the bank accounts and every single transaction to several people. It's a huge hassle. If you don't trust them, don't choose them. But, okay, Mom, if you really think that you want that as a safety valve, put it in that she needs to report maybe on an annual basis, but I want the ability to say, no, we don't want it. So I don't know what she put in her power of attorney, but I imagine that it's something like that. And what I plan on doing is every year I'm going to write her a letter saying, I don't need a report.
Cover your bases.
Exactly. Okay, so that story demonstrates the issues that I want you to think about when you're choosing a power of attorney. The person needs to consent. She called me and said, Troy, I want you to be my power of attorney. I said no. So she couldn't and she shouldn't name me as a power of attorney because I haven't consented to it. And if you choose somebody, you need to ask them and they need to agree to it. It's practically a strong recommendation anyway. You don't want to choose somebody and then it turns out that they go, I'm not doing that. So you need them to agree just from a practical perspective, but legally, of course, they need to consent. Number two, they need to be capable to do the job. I'm capable of being power of attorney for my mother, obviously. But so is my sister. She's not a lawyer. She's an administrative assistant. But that doesn't mean she's not capable of going to the bank or even selling the house or whatever. And the last point, available. I am not as available as she is, because I'm a province away. So, Ariel, my little sister, much better choice than me. And you should consider those things when you choose a power of attorney as well. Just like a proxy, on the proxy form there's the first and then there's the consecutive second. Power of attorney, you should have a first and then you should have an alternate. Here's another important point. A lot of my clients come to me and they say, I want my 2 children to be my power of attorney. And I say, choose one. If you choose 2 people, they can disagree. And I know that everything's hunky-dory today, and everybody's getting along today, but unfortunately, in my line of work, I see all of those examples where it has gone bad. And if she, my mother, chose me and my sister Ariel to be jointly power of attorney, and Ariel and I disagreed, nothing would happen. And if there was no other alternative, the power of attorney would fail. If you feel, like some people feel, that the child who is not picked is going to get hurt feelings because they were not picked to be power of attorney, I assure you that is not the case. It's a lot of work to be somebody's power of attorney, and it's usually not fun. And you usually don't get paid for it. It's running the bank, dealing with the investments, dealing with sale of property, dealing with real estate agents. It can go on for years and years and years. It's no great prize to be picked. So I reassure you that you don't need to make your 2 children joint. If you have 3 children, I still don't like it, but it's better than 2, because at least there's a tiebreaker. Always an odd number. If you're going to have many people do one thing, but it's just better to choose one of them, and if they can't do it for whatever reason, then the second one. It is a, well, springing power of attorney. And like it sounds, it springs into effect upon the occurrence of an event. Now, springing power of attorneys are particularly relevant for discussions of people who have mental challenges and disabilities. The most common kind of a springing power of attorney is that this power of attorney comes into effect upon my becoming mentally incapable of managing my own affairs. Unfortunately, there's a problem with the springing power of attorney, and I don't recommend it. And that is that in order for it to spring into effect, it needs to be proven that you no longer have the mental capacity to do the thing, to manage your life and to manage your affairs. The way that you prove that is you hire a lawyer and you visit a couple of doctors, and the doctors swear affidavits that you lack mental capacity, and then the lawyer takes that affidavit plus the affidavit of somebody else and goes to court to get a judge to confirm that in fact you are mentally incapacitated. So practically speaking, it has a big hiccup, right? It has a big problem and why it might fail. Because somebody needs to go through all that hassle, time, and expense in order for the springing power of attorney to take effect. The power of attorney, a general and enduring power of attorney, is exactly like it sounds. It comes into effect upon signing. It covers all circumstances. It's not limited in any way. And it endures notwithstanding any mental incapacity that might befall you. Incidentally, under the Power of Attorney Act of Manitoba, it expressly says that if the power of attorney does not have a sentence in it saying that this power of attorney continues and endures, notwithstanding any mental incapacity that may befall me, or similar language, it will fail upon your mental incapacity. So the law says it will fail unless it has the specific sentence in it, which creates a circumstance which is a true disaster, where you go to a lawyer and you get a power of attorney because you think this is prudent and responsible to do, and you think, I'm getting this just in case something happens to me. Then something happens to you, and suddenly the power of attorney is no longer valid. Right?
So which kind of power of attorney do you get?
Then you only have a power of attorney that lasted up until the moment in which you needed it. Right? What I would tell you, because I have seen it, is go and dust off your power of attorney if you have one, and make sure you look through it for a sentence that says, this endures notwithstanding any mental incapacity that might befall me. If it doesn't have that sentence in it, you probably need a new power of attorney. Here's the problem with wills and estates and power of attorney work. Lawyers don't make a lot of money from this kind of work. They do it as a lost leader. Some lawyers will give you a will for $200 or $250. If a lawyer is giving you a will for $250, they're not spending any time on it because lawyers bill $200 an hour or $300 an hour or $400 an hour. If they can make $400 an hour working for some commercial client, they're not going to have any interest in doing your will for $200. So they'll have a standard form that they use, and their secretary will do the work, and they'll come in and spend 15 minutes with you, and then they'll either give you the will or they'll put it in the vault. I don't practice that way because I was raised properly. I also charge more. I usually spend 4 hours working on wills and power of attorneys with my clients. I spend an hour or an hour and a half meeting with my clients in the first meeting. Then I prepare the wills pursuant to their instructions. If there's any questions, there's a back and forth. Then I sit down with them. I go through everything with them again. Then we oversee the signing. I charge $500, $475 for this package we're talking about, which is still not what I would get if I did 4 hours of work for a commercial client. But I consider this work important because I like helping people this way. So how can it happen that a lawyer would have a power of attorney that doesn't have this essential clause? It's because they don't do wills and estates. They don't spend any time on it. They're only doing it to meet new clients so that maybe somewhere down the road they might get some good work, that is high-paying work. And then you might end up getting a bad product. So check your powers of attorney if you haven't, because I have seen it before. Those are the three kind, and like I say, I recommend the general and enduring, and make sure you have the enduring clause. Now, about powers of attorney, and this is a segue to the next topic, which is related to it, which is committeeship. I've become Harvard Joan now, because my S didn't fit on the page. Yeah.
I have a question. How often should you kind of review your proxy and your POA?
You should review all of these legal documents. You should review them every 5 years, or on the occurrence of a major life event, like birth of a child, marriage, death, selling of your house. Any major event like that, sale of major property, or personal change of circumstance, you want to be pulling these documents out and taking a look at them. If you don't understand them, go to a lawyer. It's worth it to spend an hour with a lawyer to have that reassurance. What kind of powers do you need to give under the power of attorney? Most of them are pretty mundane. You don't need, and a power of attorney can hire professionals. Like, for example, I can't do my tax returns, or my sister can't do my mother's tax returns. She's not going to do the tax returns herself. She's going to hire H&R Block or some accountant to do that, but she can do that as a power of attorney. So I think that the bar is not that high, but at the same time, when I talk about capable of doing the job, what I'm saying is, don't choose somebody who has a drinking problem. Don't choose somebody who has problems like ADD, where they have gone through life and they're always sort of like, they've got great plans and nothing ever sort of happens, and they don't execute on the things they say they're going to do. That's not a competent person to choose. Yeah. I always have to make sure, thank you, I always have to make sure that the person here can sign the power of attorney. What often happens in my line of work is I get a call from someone saying, there's a problem. There's an aunt, or there's a mother, there's a friend, or what have you, who has been declining for a number of years, and it's really reached a point where they can't manage their affairs anymore. We need help. And my question for them is, and I had a conversation just like this last week, is there a power of attorney? And they often say, what's a power of attorney? Right? That's not a good sign. Because by the time you've got to that point where the person's been going down, and it's too late. This is the cutoff, and now they're not capable anymore. And I'm saying to them, well, do you have a power of attorney? No. Okay. Actually, we should do the line like this. This is the line of competency. So here they're fully capable, and then you see they dip under the capable to understand the document. Then they're back up, and then they're no longer capable, and then they're back up, and then they're really not capable, and then there's this little moment when they're actually with it again, and then they're back down. And this is where people call me. It's too late.
Yeah.
I can't push them back up. And they always say the same thing. After I explain to them, in order for a document to be legally binding, somebody needs to understand the nature of the document, and with respect to a power of attorney, they need to understand their stuff. So, if I meet with somebody, because usually what will happen is, I get the call. We need help. There's a problem. And so-and-so is no longer capable, and so-and-so needs to take care of her affairs, and we went to the bank, and they're telling us they need this thing. What is going on? And I say, please bring her in. When's a good time? When is she good? When is she on? Well, she's usually good in the mornings. Okay, why don't she come in at 9 a.m. tomorrow or on Thursday or whatever, if you can catch her in a competent moment, and I can sit down with her, and I can ask her a series of questions, and she understands who she is, what her name is, what her house, what her property is, how many children she has, what are the ages of her children, that kind of question. Yes, 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 yes. Okay, green, 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 right? Check, 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 check. Okay, this person understands. Get them to sign now. There's still a potential legal time bomb, right? Because if we catch them in that moment, and they sign a power of attorney, hallelujah, right? Power of attorney is, this costs, remember I charged $500 for the package? $500. Well spent, because it saved the day. But if the person who now is the attorney is somebody that some son or sister-in-law or whatever disagrees with, they're going to say they weren't competent to sign this power of attorney. And then we're going to be into a fight about challenging how valid it is, because you just captured that little moment when they were on. And anybody who dislikes the power that's been given to the person with the power of attorney the first thing they're going to do is say, they weren't competent to sign that. You tricked them into doing it. You got them to sign it and they didn't know what they were doing. And now you have taken all their money and off we go to the legal races. So, this is the point where you want to be signing power of attorney, when no one could challenge it. I asked the question, who would not like this power of attorney? Who's out there? Who's going to sue? That's the question I ask. If the answer is, oh no, nobody's going to sue, okay, well I may not believe them. But if that is the truth, that no one is going to have a problem with this, there's no problem. No one's going to challenge it. I mean, if they're down here and they're just sitting in a wheelchair and in a vegetative state, it's ridiculous. But that's not usually the case. Usually it's at the borderline when we have these problems. So, and the way you do it is you get a lawyer to confirm they lack testament or legal capacity, or you get a doctor to confirm they lack capacity, mental capacity. Doctors usually don't want to do that. They usually say, hey, lawyers need to do that. But I can work with a doctor, and it's true that they know things that I don't know. I can say, what's your name? Where do you live? What do you own? Who are your children? I can ask them those questions, and if they can't answer them, then unfortunately I turn to the people who brought them in and say, this isn't going to work. Okay? So capacity is important for power of attorney. Now, committeeship. If the individual's down here and now it's a problem, and it's been identified that they are not capable of signing a power of attorney, but somebody does need to manage their affairs and there is no power of attorney, then you have to either go for a public, well, you don't go for a public committeeship. The public trustee steps in. The state takes over control and gets an order of committeeship against the individual. So the individual no longer has authority and rights to make decisions for themselves. The state makes decisions for them. And the public trustee charges the estate of the individual a significant amount of money for the privilege of taking away their rights. Or you do what's called a private committeeship. And that's when I work with my clients. So there's the public, and then there's the private. And I get hired by clients to seek orders of committeeship for their loved ones routinely. It is always a sad story. Sad on multiple fronts. But here's the reality that I want you to know. When someone comes to me, I say, this is going to cost you $3,000 to $5,000 just to get started. It's going to take months. We're going to need an affidavit. We're going to need to prepare an application for an order of committeeship, asking the court for an order. We're going to need an affidavit from you saying, here's my circumstances and the circumstances with respect to the individual and why I want to be chosen. We're going to need both doctors to swear affidavits saying the person lacks capacity, mental capacity to manage their own affairs, and that it's incurable, and that they're likely not going to improve. And then we need to go to court, and then we need to go before a judge, and we need to get the consent of the public trustee, and then, if we're lucky, we'll get the order. The process takes months, and it takes a fair amount of time for me. It's not unreasonable for me to spend 10 or 20 hours preparing the documents, going to court, dealing with the doctors, etc., etc., etc. And it's a big cost. So time and the cost and the emotional cost. In the fall, I went back to court for one of my clients who has an order of committeeship with respect to her relatively young husband who suddenly had a steep decline in dementia now. I think he's in his mid-50s, 54. It's very sad, because not only did she lose her husband, but now she is destitute without his financial support, because he was the breadwinner. And she's paying a bunch of money to a lawyer. And here's how it works. After you prepare, right, the affidavit, the application, the affidavit in support of you, of yours, the affidavit of the doc, times 2, support of public trustee, so we have to arrange that by correspondence of public trustee, and then with luck and with effort and persuading the judge, you'll get your order. And that gives you the power to manage the person's affairs. Now you have power to manage their affairs. The same thing you would have got from a power of attorney, to act in their stead, to sign documents for them, to deal with their property. Now you have it by way of a court order. But the court orders almost always require that you come back and report. Remember I talked about the presumption of reporting in the Power of Attorney Act of Manitoba? The order will require you to come back to court, likely within 6 months of it being granted, and every 2 years thereafter. So imagine the 54-year-old circumstance, right? The wife, she's in her mid-50s, her husband's suddenly no longer her husband, and she has to hire a lawyer to go on all this, and then every 2 years she has to go back to court, and she has to produce for the report a report of all of the monies that went in and out of all the bank accounts that belonged to her husband, but of course, according to her, they were our accounts. But now the judge is reviewing every line. So every 2 years, it's 20 pages of in and out. This is for, and then we have to indicate what the expense was for. So, hotel, $1,000, and Walmart, $50, and, and CPP pension in, We have to do, it's quite a long report, so another big legal bill, and going off to the judge, and the judge is going down the line and saying, well, what's this $800 for hotel bills? And she says, that was Christmas. We went to see our children, and we had to get a hotel. And he's saying, look, I need to ask. And okay, well, here's another one, $200 for gifts. What was that? And she's getting incensed, saying, this is my private life. Not only has it been ruined, not only have I spent thousands of dollars off to my lawyer, but now you're going to go through with a fine-tooth comb? The answer is yes. And the judge says, this is my job, to make sure that you, as attorney, as committee, aren't stealing any money. And she says, but it was our money. And the judge says, no, it's your husband's money. Right? It's his house, because you weren't on title. It's his car, because you weren't on title. Right? It's his investments, because you weren't listed as a designated beneficiary. So this is always a very, very sad story. And I will do everything I can to capture people in this moment and charge them a couple $100 rather than put them through this nightmare. But if you're down here, or if the individual is down here, there's nothing you can do if you need access to their property, their funds, or anything to push them back up over the line. Okay? So this is the cautionary tale. Don't end up in a committee shed. Get your power of attorney now, right? While they're capable and competent. Let's get the rest of it done. Okay, all of that. Oh, yeah, I told you about the air kit.
Yeah.
Right? Okay. So we talked about, I spent the last hour talking about this because this is what matters to you before you die. Right? Most people call me and say, I need a will. Right? The will, your stuff after you die, like not nearly as important as this stuff. To you, of course it is important. You know, that's your love letter to your loved ones after you go. And then, as for your body after you die, you should probably put together a funeral plan. And I don't do that. But it's smart to do. I do think, power of attorney, a couple $100, honest to God. Like, people say, I need a will. And then they get upset when I tell them I charge, usually about $500. $500? But, mostly, this is what I'm helping them with. And I'm giving them the package. I will also do your will. And will is important. If you're like me, you learn better by stories. So I've told you guys a couple of stories, I'm going to tell you another one. A woman comes into my office, she wants to do a will. Same call as usual. I need to update my will is the most common call I get. And when they want to update the will, they don't even want to pay even $250 because it's just an update. I'm just changing this to this. So she calls me up, I want to update my will. I say, come on in, we need to talk. I spend an hour and a half with her. I go through this, my will information preparation checklist, which is my little cheat sheet of things that I want to talk to you about. Sometimes I just send it to them. Please fill it in and then we'll talk about it when you come in. I did so with her. I sent it to her before the meeting. And in my will and preparation information form, at the tail end, there is a page about your assets, and then a page about your liabilities. And a number of my new clients say, I don't want to tell you that. So, it's my stuff, and I'm just giving it all to my children equally. So why should I tell you about this? Which is exactly what she said. Bear with me, I say. Just, help me out here. Because I need to know if you have a significant asset so I can give you good advice on it. Like, for example, if you have a bank account somewhere, like in another province. Oh, I have one of those. Oh, well, where's your bank account? It's in British Columbia. Okay. You used to live in British Columbia? Yes, I used to live. I just moved to Winnipeg because I want to be with my daughter. Okay, fine. How much is in that bank account? $500,000. Oh, well, that's important for me to know about. Tell me a little bit about this bank account. Oh, I own it jointly with my first son. Okay, now you know how it works with joint. I told you, it's my bank account with my wife, right? If she dies, it's still mine. So she has $500,000 jointly with her first son. She dies, it's still his. Her estate was worth $1 million. Half of the estate was this bank account. What were the instructions under the will? To my 3 children equally. But here's how it would work. $500,000 gets divided equally 3 ways. $500,000 goes to son number 1. That's not equal anymore. She says, oh no, I've talked to my son and I trust him and he knows that he's to divide it equally just like I want in my will. Okay, he's probably a great guy. Okay, and he's probably not going to screw his children. He's not going to shaft his siblings. Everything's probably going to be fine. It is true, given my line of work, I've said that a few times, I see the bad situations that come up when it doesn't go as planned. But let's give him all of the benefit of the doubt, that he will honor his mother's wishes, and his intention would be to take that $500,000 and to break it into 3 pieces, keeping one for himself, one to his sister, one to his brother. What about son number 1's wife? What happens if they get a divorce?
She gets half.
She gets half of everything that is his. Thank you, says daughter-in-law. I explain this to her. She says, oh, I need to think about that. She comes back and she changes her will. Actually, no, here's what she did. She took that account out of joint. So, answer your question, is joint always good? Depends, right? So she took that account out of joint, then it would follow through. Now, here's something I need to warn you about. The reason why she put it in joint, and you, if you have discussions with people in your life, family, friends, and relations who are not lawyers, be warned, they're not lawyers. Always remember that. People will tell you this. Oh, you can avoid probate fees if you put an account in joint. That's what she did, my woman in the story. Someone told her, you can avoid probate fees if you put it in joint. That is true. If it's in joint, it's not part of the estate. It just stays his, just like it always was. You won't pay probate fees. Probate fees in Manitoba are $1 for every 1,000. So, what is that, $500?
Yeah.
I don't think, my advice is don't get hung up on probate fees. When you're giving your children $1 million, don't worry about the probate fees. Get the will right. Okay? My goal when I'm doing a will is to make sure that there's no fighting after you die. Hopefully everybody's happy. Hopefully everybody's having a party and celebrating your life with fond memories, and they're so thankful of whatever it is that you happen to leave them, be it sentimental or financial. But if they are not, and if they are disgruntled, they can be mad at you if they want, but when they go to a lawyer and say, I want to contest this will, the lawyer will tell them, you are going to lose. I don't want to take your money for a losing case. That's my goal. Whatever you decide, it will be ironclad. That is what will happen. And then, as long as we take care of that, then we can get on with doing good things and providing lovely bequests for the people that you love, and charitable bequests. Just one thing before I go. Charitable bequests. Most of my clients don't make charitable donations or charitable bequests. That is, gifts to a charity in their will. And it's really a shame. Take the woman with the $1 million estate. But even, let's forget about the $1 million estate, because most people say, I don't have a $1 million estate. My estate is very modest. I could challenge you on that, because when I do my asset list, I find that there's a fair amount of money sitting around, and maybe you didn't know. Even if you're just sitting on a house that you bought for $50,000, often worth $300,000. And then that gets you well on your way. But let's say your estate is only worth $300,000. Okay, and you have 3 children. So you want to split it equally in 3 parts. So 100, 100,000. The way it works is when you die, the person will go to a lawyer, and the lawyer will prepare probate documents to go to the court to get the court to give them the authority to administer the estate. The court, being satisfied that the will is in order and that the person is properly appropriate to do the administration of the will and that they're not going to abscond with the estate, etc., will give them the power to administer it. Then the person who's designated, that is the administrator or the executor, does the things that the will says to do. If the will says, I have 3 children, I want it to be broken into 3 parts, and I want it to be given equally to 3, that's what they'll do. They make 3 shares. Of course, they'll have to take in everything that belongs in the estate, sell it all, if there's specific bequests, my Terrywinkle teacup to my daughter, they'll take that out and give it to the daughter. But after they do the specific bequests, they will convert everything into cash. They will pay off the debts, including the taxes. And after that, after paying the debts, paying Canada Revenue Agency, and importantly, getting a clearance certificate from the government saying all the taxes are paid, then the balance remaining will be divided into 3 pieces and given to those individuals, and then they'll say, hallelujah, money from grandma or grandpa or whatever, okay? Here's the thing. If you're giving your children $100,000 or so, let's say you love the Humane Society, you love those cats, you love looking at cat videos or dog videos or whatever it is. It doesn't matter what you care about, but if you're passionate about it and it's a charity that you think deserves support, Alzheimer's Society maybe, I don't know, put in a little plug, and you say, well, you know what, well, here's what I need to tell you. There's a taxable benefit that is available to people when dealing with estates. Basically, you get half of it back. Your estate gets half of it back. So, $300,000, instead of doing 100, nothing for the Alzheimer's Society, you decide, you know what, I'm going to give $30,000 to the Alzheimer's Society. Sounds like a lot of money. The Alzheimer's Society would be more than pleased to receive it. Good charity or Humane Society or whatever it is. Of course, the estate gets half of that back. Right? So they have to file their taxes and they get their clearance certificate, and when they file their taxes they get a credit, and the credit goes back, another $15,000 goes back. So we'll just put 15 in here. So it actually only costs the estate 15. Then 15 comes out of 300. Well, let's not do the math. We know 15,000 divided into 3 parts is 5. So instead of getting $100,000, you're going to get 95. Do you really think that your kids are going to be upset when they get $95,000 instead of 100? Not at all. Meanwhile, Alzheimer's gets 30. That's when I explain it like this to clients. They say, "How much do you think I should give?"